The commission will come to order. This is the time and place set for the pre-hearing conference in a joint application of Southern California Edison Company and San Diego Gas and Electric Company to find the 2014 SONGS Units 2 and 3 decommissioning cost estimate reasonable and address other decommissioning related issues. This is application 14-12-007. Good afternoon. I'm Administrative Law Judge Mary Beth Bushy, the assigned Administrative Law Judge to this proceeding. Also presiding with me this afternoon is the assigned Commissioner, Commissioner Florio. Commissioner, do you have any comments that you would like to? Thank you. Then we will move on into a status report from the parties. I issued a ruling setting this pre-hearing conference and directing the parties to meet and confer regarding the scope and the procedural schedule. Mr. Matthews, would you like to begin?
Sure, thank you, Your Honor. Walker Matthews on behalf of Southern California Edison. First, Your Honor, we'd like to report that the parties have complied with Your Honor's March 9, 2015 ruling that requires the parties to meet and confer regarding the scope and schedule for this proceeding. SCE and SDG&E scheduled that meeting for Thursday, March 26th, and we met and conferred with the parties as directed. We felt the meeting was productive. Let me first start by saying that during that meet and confer, as SCE is indicated in papers that it has submitted in this proceeding, that the scope of this proceeding should be focused on the reasonableness of the SONGS 2 and 3 decommissioning cost estimate that SCE has submitted. It should be focused on the reasonableness of the utility's request for the contribution amount to be set to zero and other related rate-making requests in that application. We believe that this scope is consistent with the scope of prior NDCTPs and the Commission's reviews of DCEs. It's also important to note that the scope of prior NDCTPs. In typical NDCTP, as Your Honor is aware, the Commission has reviewed the most recent decommissioning cost estimate, the sufficiency of the trust, and the sufficiency of the customer contribution levels that are being requested. Okay. In some NDCTPs, the Commission conducts a reasonableness review of incurred decommissioning costs. Here, as SCE understands it, the Commission has ordered a different direction and has required the utilities to submit the DCE for Commission review in this proceeding, and then ordered a reasonableness review of 2014 costs to be completed in a separate proceeding, okay, which is now pending in a different docket. So, therefore, it's SCE's position that unless there's a consolidation of this proceeding with that separate proceeding, that this proceeding should not address the 2014 activities and costs. It should be limited solely to the DCE. We discussed this with the parties, and in general, I think there's general agreement regarding the scope of this proceeding. However, there are a few issues that have been identified by parties that I would like to discuss now that SCE disagrees as being within the scope. The first was an issue raised by Ms. Gilmore in her Prehearing Conference Statement that identifies a number of issues and allegations concerning SCE's selection of Holtec as the supplier for dry cask storage at SONGS. SCE believes that this should be out of scope because those issues fundamentally relate to radiological health and safety issues that the Cpuc has previously kept out of scope in prior decommissioning cost estimate review proceedings. Instead, the Commission should only consider whether the costs that SCE has estimated in the DCE for spent fuel management are reasonable. That should be the focus of the Commission's review. The Commission should not focus on the selection of a particular vendor or a particular technology. We discussed this with the parties. There was disagreement, and we came to the conclusion that it needed to be discussed further here. But that is SCE's position. We would also say that consideration of that particular issue regarding the selection of Holtec, in Edison's view, would bog down this proceeding unnecessarily and cause unnecessary delays. So that's one issue where there's disagreement. The second issue where there's disagreement is with the Alliance for Nuclear Responsibility. The Alliance essentially asked that this commission reconsider its prior order to the utilities to discuss site restoration requirements of the Navy easement on the Sauk site in an effort to reduce decommissioning costs. The Commission directed us to discuss that issue with the Navy to see if decommissioning costs can be reduced. The Commission decided that issue several years ago in the prior to DCTPs. We are complying with that requirement and are in current negotiations and discussions with the Navy. However, the Commission shouldn't and doesn't need to reconsider that requirement here. Now, there have been some parties, and we discussed this last Thursday, that suggested, well, that the potential savings resulting from those discussions should be within scope. Okay? SCE has reconsidered those positions and agrees that to the extent we're talking about potential savings and how it should be applied in this DCE or future DCEs, that's generally properly within scope. Except we will note just briefly that the discussions are ongoing. They are just beginning, and it may be premature to consider the total amount of savings that may be available. Just a few more issues to identify for your honor. There was also disagreement regarding the citizens' oversight, an issue that they raised concerning a citizens' oversight panel. We believe that they raised this issue in the 2012 NDCTP. The Commission has considered this issue and determined that based on the information that was presented in that proceeding, that the Citizens Oversight Panel did not need to be created. We therefore believe that this issue is outside of the scope of this proceeding. We'd also note that the issue concerning oversight panel and review of costs, in SCE's view, is outside the scope of this DCE proceeding. It's more of a reasonableness issue, so we believe it's clearly outside the scope of this issue. It generally has already been addressed by the Commission. The final issue that I'll note, Your Honor, regarding the discussion that the parties had during the March 26th meeting dealt with reasonableness. SCE has raised reasonableness the reasonableness standard as an issue in this proceeding. Okay. We've also filed an application for a rehearing at the Commission to reconsider its 2012 NDCT decision in regards to Songs 1 costs. SCE recognizes that this proceeding should be limited to the DCE, so to the extent that the Commission wishes to address the reasonableness standard in the reasonableness review proceeding, that's an acceptable result. But we do think that in some proceeding, the Commission does need to review that standard to ensure that the standard that it is applying with respect to its review of costs is consistent with state law. I'll end my comments by again noting that we believe that this proceeding should be straightforward. I think the 2012 NDCP decision on pages 59 and 61, as well as conclusion of law number 1 in that decision, stated the scope of the DCE review in the correct way, which is to say that the scope of the Commission's review of the DCE should concern such things as the methodology used to develop the DCE, the validity of the assumptions made. Those are the types of issues that should be within scope. That decision, further noted on page 21-22, of what should not be in scope. It should not include the operation of the spent fuel pools. It should not include a discussion or raising of issues regarding the types of CAS being selected, and should not concern related spent fuel operation, including those concerning radiological health and safety issues. So that's, all this was discussed, and I know I've said a lot. Appreciate your patience. Again, we thought the meeting was helpful. We actually did narrow the issues that SCE is disputing as being out of scope. I've gone through those issues. I'll also finally note that in terms of schedule, there's a general consensus reached on schedule, where the agreement would be to adopt the ORA proposed schedule, which had hearings set for
Mid to late August.
Mid to late August, with a decision prior to the end of the year, if that's possible. The one additional thing that we would want added to that schedule is a May 11th date for supplemental testimony by SCE in the 2012 NDCP decision, which was issued after we had submitted this application. The CPC directed that we provide testimony regarding severance, as well as testimony regarding cost categorization that is included in the DCE. So we would ask for a May 11th date for SCE to submit that additional testimony. And we don't believe that any of the other parties object to that date.
Thank you, Mr. Matthews. I have one question for you. Is the end of the year a significant event in the overall decommissioning cost estimate proceeding? That is this a must-go by end of year?
No, Your Honor, I wouldn't characterize it as a must-go. It's a request that the utilities have for an expeditious review and possible decision by the end of the year. But it's not a must-go.
Okay, because I see you give me all the 30 days to write the PD and get it mailed, and that puts us right in the middle of the end of the year and the holiday season, which around here is a very busy time.
Sure.
So if end of year was important to you, we would have to take a hard look at the schedule. Okay?
Your Honor, if I could make one comment on that. This is Emma Salustro representing SDG&E. In our prayer for relief, we did ask that the Commission find reasonable that we go from our current repair collection of about $8 million a year down to zero by the 1st of January 2016. So while, again, this is not a must-do, must-hit situation, please understand that we will still have to contribute to the trust the $8 million annually until we do have a commission decision to go to zero. So if the commission were to entertain a motion, interim motion, for example, to suspend those contributions, if the commission finds that to be appropriate, that would be helpful towards the end of the year. Once the money goes into the trust, it's very difficult, if not impossible, to reverse that deposit.
And get it back out?
Yes.
Okay.
SCE agrees with that, Your Honor, regarding the particular request relating to the contribution levels.
Okay, we would need to work that into the schedule because that's going to take a commission decision to do that, to approve basically suspending those collections. Yes.
Your Honor, Matt Friedman on behalf of TURN. In the last nuclear decommissioning cost triennial proceeding, Southern California Edison unilaterally decided to suspend its contributions to the actual trust itself. They collected the money from ratepayers, but did not actually deposit the full amounts in the trust pending the outcome of a commission decision. I don't see why SDG&E couldn't do the same thing here. I agree with Ms. Salustro that once the money formally goes into the trust, it doesn't come out except as an expense. However, SDG&E may collect any money that it has in a revenue requirement, hold that money pending a final commission decision, and then that money may be refunded to customers or deposited into the trust, depending on the outcome of the decision.
There had to be some sort of accounting, but I suppose they do that anyway. So maybe that might be a solution.
As long as the commission is aware that that's the reason why we're not making the deposits as we've been directed to do into the trust, but merely holding them pending a commission decision, subject to check with our accountants, I think that should be a reasonable solution.
Okay. Mr. Giesman?
John Giesman on behalf of the Alliance for Nuclear Responsibility, Your Honor. I would point out the question as to whether the trusts are adequately funded, particularly with respect to the assumptions that Edison and San Diego have made regarding the duration of on-site storage of spent nuclear fuel, represent core issues that my client and several of the other parties are raising. So in terms of trying to make an interim decision, we should be clear that will involve a large portion of the issues raised in the proceeding itself.
Which is why the funds would have to be held.
Correct.
Okay. Let's see, Ms. Elster, well, do you want to continue with your status report, or do you have anything to add to Mr. Matthews?
Just a short comment. First, we echo everything that Mr. Matthews mentioned a minute ago. Second, in regards to the topic of negotiations with the Navy, again, we agree with Mr. Matthews. The Commission directed Edison and SDG&E to try to negotiate with the Navy concerning the terms of the lease agreement. While the subject of potential cost savings as they relate to the DCE, whether the way that we have estimated the cost of remediation of land is reasonable, we do believe that's the scope. However, I want to caution the Commission that these are ongoing negotiations between the attorneys for the utilities and the attorneys for the Navy. They are certainly not close to final. So if the parties could try to respect the fact that these are privileged negotiations that are ongoing, that we don't know what the outcome is going to be. We don't know if there will be any savings at all as a result of negotiations. That would be helpful, so we don't have to get into discovery arguments concerning possible privileged information regarding negotiations.
Well, isn't that why we call this an estimate?
Yes.
So I think let's not anticipate any discovery issues, and we will handle them when we get there. Okay?
Yes.
If we have to. All right, anything further, Ms. Elster?
No.
Okay. Thank you. Let me see. All right. It looks like it's not Mr. Hyde.
It's not Mr. Hyden, and it's not Mr. Lee. I'm standing in for both them. I'm Laura Tedisco, and I'm representing the Osprey Fair Advocates in the absence of Mr. Hyden and Mr. Lee. I was not a part of the conversation that was held by telephone conference on the 26th. My understanding that was consistent with the way Mr. Matthews related it, and I believe that the schedule that already proposed in its Prehearing Conference Statement is still the one that was proposed now, so I don't have anything further to add.
All right, thank you, Mr. Disco. So can we expect Mr. Hyden to return in your appearance here to be just your sole appearance here?
Yes.
All right, thank you. All right, now other parties. Who shall we start with? Why don't we go back to Mr. Friedman and then work down from there?
Thank you very much, Your Honor. I would just touch on 3 issues, one of which was mentioned by Mr. Matthews, 2 of which we have identified in our protest and pre-hearing conference statement, which have not yet been fully addressed. The first involves our request for consolidation, which Mr. Letts, I believe, has also made a motion along those lines, to consolidate this proceeding with application 1501-014 and 1502-006, the SONGS 2014 reasonableness reviews. From our perspective, it doesn't make any sense to have these proceedings operating separately in parallel. They address common issues of fact, policy, and law. And the utilities are asking for determination of reasonableness in the 2014 reasonableness review proceeding based on a comparison with the revised decommissioning cost estimate that is the subject of this proceeding. In other words, if the Commission finds that the revised decommissioning cost estimate is not reasonable for some reason in this case, yet it has allowed the utilities to benchmark spending against their proposed decommissioning estimate in another case, we end up with a complete disconnect between these proceedings. In addition, the utilities are asking for determinations regarding the legal standard for determining the reasonableness of expenditures, whether they get a presumption of reasonableness if it's below an estimate level. They're asking for similar relief in this case. We can't have the Commission looking at the same issues in 2 completely separate proceedings.
Well, Mr. Friedman, is the obvious solution to that to do them sequentially rather than simultaneously?
We would support sequential consideration of these issues so long as this proceeding goes first, because we believe this is the proceeding where the Commission needs to make key determinations about the reasonableness of the decommissioning cost estimate itself. If the Commission were to sequence either in phases or to sequence the proceedings themselves, we would not object. That's our first issue. The second is we have identified our objections to Edison attempting to relitigate the issue of whether they are entitled to a presumption of reasonableness if expenditures come in below the levels estimated in the last cost estimate. Edison has now litigated this for 5 straight years. They got an adverse decision from their perspective in decision 10-07047. They misunderstood and misconstrued that decision in the last NDCTP, and the Commission made them aware of the fact that they had been engaged in a misperception as to the legal standard. The Commission clarified that standard in decision 14-12-082, and Edison now has an application for rehearing pending. Meanwhile, they're asking the Commission to revisit this issue again in this case. We don't think it belongs here. We think that the application for rehearing speaks for itself, and the Commission should decide those issues in response to that application. And then finally, the last issue, Mr. Matthews suggested that the Commission should not apply any scrutiny to Edison's decision to select particular vendors or technologies as part of their decommissioning cost estimate. This was in response to Ms. Gilmore's statements. We have serious concerns with the Commission accepting that proposition. Edison has a series of assumptions in the decommissioning cost estimate relating to specific technologies or processes they would use in the decommissioning of the plant. Those are clearly fair game for us to examine and challenge on a cost basis. Did Edison consider the relevant costs and benefits of alternatives? What kind of cost containment might be available? Or what kind of accountability mechanism should there be put in place? This is exactly what we did in the last NDCTP with respect to PG&E's Diablo Canyon estimate. The Commission looked at certain assumptions PG&E had, disagreed with some of those assumptions, and changed the cost estimate. If we can't do that here, I'm not sure what we're doing in this proceeding.
All right, thank you, Mr. Friedman. Which of our interveners would like to go next? I will. I'm pointing and 2 people think I'm pointing. Let's go to the gentleman in the back.
Sorry. Yes, my name is Ray Lutz. I'm with Citizens Oversight. And thank you very much for letting me speak today. First of all, the Citizens Oversight made a formal motion regarding the consolidation of the proceedings that Matt Friedman of Turn just mentioned. There are 3 proceedings. 2 of them, this one and 2 others. The 2 others are basically identical, except they're coming from 2 different companies that both share in that. And I see no reason at all why we should have 2 proceedings. In fact, it's been even talked about here today that there's 2 proceedings, when in fact there's 3. So the other 2, which deal with exactly the same information, should be consolidated. We didn't see the motion in the docket. I don't know why it was rejected. Does anybody, do you know? Was there some reason that our motion was not put in the docket?
No. Did you contact the docket office?
Well, we submitted it in a normal way, and we got a receipt, but it's not on the list, and it was been served. No one said that there was any reason to reject it, so it's just not in the list. So, okay, I guess I can contact them if that's the answer.
Could be just a delay in processing.
That could be. So I'll look into that. If no one knows anything, that's probably what it is. Now, Turn says that we should do the DCE approval first so that we have the cost estimate, so that then we could evaluate whether their spending is reasonable based on the cost estimate. And that sounds pretty good, except for the fact that they may be continuing to do elective work. Now, during 2014, the plant was turned into what is like cold and dark mode, is what they call it in the proceedings, where they had to do certain things in a timely manner at the plant to shut it down. But there's been some proposals of work to be done, such as the installation of the ISFAC using the famous Holtec design and so forth, which doesn't have to be done right away and could be deferred until everything is over here. So if they're going to continue working before the DCE is approved, then we have a little bit of a problem with that because we haven't even reviewed the cost estimate, and they're going ahead and doing work. So this is why I think it's putting the cart before the horse there. So we would like to continue to assert that that there should be something done to stage these proceedings, to state perhaps in this one that no further work should be done until we approve the cost estimate. And then proceed on, did they do something reasonable before they even had the cost estimate done for last year. We asserted in our objection after the NDCTP to their advice letter that they had not even done the PSDAR, the post-shutdown activities report, nor the DCE, and were starting to do work, and had a lengthy 260-page advice letter and a whole process of how to do that, and I understand that's been told. So we're happy that it looks like the commission is going ahead and doing these a year at a time, and so that's a good step in the right direction, so I compliment everyone on that. Let me turn on to the next issue. Mr. Matthews just talked about that the utilities want the proceedings in the entirety of the CPUC to focus only on their requests and not on the larger issues. In my short tenure here working with the CPUC, I think this is a bit of a problem because we need to be also taking a proactive role in heading off big mistakes that may be made if we only cater to what the utilities ask us to do. One of these is the disposition of the nuclear waste. It's been proposed, I saw that Mr. Aguirre suggested in an email, and we support this idea of establishing an advisory board to be headed by distinguished nuclear safety experts and with citizen participation. And this will be charged with the duty of developing a timely proposal to relocate the 3.6 million pounds of nuclear waste at San Onofre from this coastal location, which has problems, and put it in a safer, more remote location. It's a safety issue, but it's not one that the NRC has jurisdiction over. They have jurisdiction over the canister design and the cast design and whether or not it is safe. They do not have jurisdiction over where it's built. And so that someone can say, well, the CPUC maybe not, can say, we don't have jurisdiction over that either. Someone needs to have jurisdiction over this. And if it's not the CPUC, I think the question is who does? And would it be feasible for the CPUC nevertheless to have this advisory board that would develop with these experts some proposals about what to do, and then that would go up the ladder to whoever does have that responsibility. Finally, the citizens oversight panels, we did attempt to get this in the NDCTP in 2012. It was not processed at that time because it was regarded as out of scope, and the utilities adamantly requested that it be stricken from all of our testimony. So it has not ever been included in one of these proceedings at all, except in our final comments to the proceeding. The reason that we suggest this is because this type of a project is much like many other projects that are performed throughout the state, and it is not like the regular utility business where they need to spend money sometimes without pre-approval because they have to get energy out to the customer, and sometimes they need to take actions along those lines. And this one is a project we know that has to be done. It's not that timely of a project. It can be extended out a decade and not hurt anything too much with the project. What we'd like to do is see it approved first, and then this oversight panel deal with the day-to-day, not day, but probably month-by-month issues. Let me give you an example. We just heard from Governor Brown about the water situation in the state, and there's a concern now about the plans of the decommissioning plants. Are they going to be using fresh potable water in any way in the decommissioning process? This is an issue that no one was really talking about until probably yesterday, you know, in in the sense that we just got some, a mandate from the governor's office to take action. This is the kind of thing where these happen all the time. If they have a panel that would be working with the utilities to address those issues on a month-by-month basis, just to make sure that, you know, if you need water, maybe we can use wastewater, or maybe we can use salt water, or maybe there's another way to do it rather than taking fresh water. This was an issue in the Sunrise Power Link, and we made the issue that they shouldn't use potable water, and they did anyway. And we documented that later, that they were just sucking out of the fire hydrants and using it on the project. And we had to catch them on that with video evidence. So without the people there watching every minute, unfortunately, mistakes happen. I'm not saying that they're bad guys. I'm saying that they just make mistakes because it's water that we need, and so no one's there to make sure that they're not doing it. So that's the end of my comments, but I would like to then say in summary that we would like to see these proceedings consolidated, and most importantly, we want to see something larger done about the nuclear waste problem. And this is somewhat, we were trying to include this in our pre-hearing statement, but I wanted to bring it out in a more focused way in my comments today. And the citizens oversight panels, I do believe that if these are regarded as advisory, and if it is a bit of a new thing perhaps for the culture here, I think that this will actually assist the utilities in getting their projects done in a timely manner with not so much overhead for reasonableness reviews later. Thank you.
Mr. Lutz, a couple of questions for you. You said that you wanted the proceedings consolidated. From that, should I conclude that you disagree with Mr. Friedman that sequentially would be a way of achieving that?
That would, well, in a way, there's 3 proceedings. The other 2, I think, should be consolidated without question because they deal with exactly the same information. It is from 2 different companies. If they're put in a sequential manner, I think that's one option. As I said, if there's no additional work done until this year, until we've gotten the DCE approved, until this first proceeding is done, I have a concern that to continue to work and move down the stream here and do stuff before we already seen the cost estimate.
Well, Mr. Lutz, isn't there a self-enforcement mechanism there that to the extent they do work that ultimately is not approved, then they are not able to recover those costs? So
in theory, I say you're right, but in practice, I haven't seen that yet. I haven't seen, in my short 2 years here, I haven't seen any reasonableness review that worked. And so they usually settle and say we've done everything right anyway. So from our standpoint, we'd like to assert the position that reasonableness reviews should be assumed not to be functional, and we'd like to make sure that they do the right thing anyway. We'd like to review it up front and make sure they're going in the right direction, because once you spend money, you can't unspend it.
Okay, Mr. Lutz, one last question on the schedule. Are you generally supportive of the schedule proposed by ORA?
We'll pretty much go along with any schedule. We're compliant with that. We're not trying to get anything done fast or anything. We just want to get it done correctly.
All right, thank you.
Thank you.
Mr. Giesman.
Thank you, Your Honor. In our pre-hearing conference statement, as well as in our protest, we identified 4 issues that we were interested in pursuing in the proceeding. Edison and San Diego agreed that 3 of those were in scope in their judgment. I want to note at the outset that the 4th issue, an issue that they had both agreed were in scope, was the joint application's attempted resuscitation of a light-handed approach to reasonableness reviews during the meet and confer session. We agreed with Kern's suggestion that issue could best be handled in Edison's motion for reconsideration of the Commission's decision in the last triennial proceeding. So depending on how that question is determined, we may only have 3 issues that we have suggested for your consideration. The issue that Mr. Matthews argues is out of scope is our desire to pursue the reasonableness of SCE's avowed intent to weaken the cleanup standard required by the song's easement granted by the Navy. And the sole grounds for Edison's belief that that question is out of scope is their view that it constitutes an impermissible collateral attack on the decision the Commission made in the 2009 NDCTP. I believe that was decision 10-07-047. I don't think Mr. Matthews is reading that decision correctly. There are only 2 places in it that mention this question of the Navy easement at songs. One is conclusion of law number 24, and it says prior to the development of the song's cost estimates for the next NDCTP, and that would have been the 2012 NDCTP, the Commission, along with other state agencies and officials and with SCE and SDG&E, should formally ask the United States Department of the Navy to clarify the applicable site restoration remediation standards that will be required to terminate the song's lease, and 2, execute a document with SCE and SDG&E that explicitly reflects such clarified standards. Apparently there was some ambiguity as to what the standards were. The Commission made a conclusion of law suggesting that it should be clarified. Didn't say it should be weakened, said it should be clarified. So the order, paragraph 10, addressing the same issue, says within 1 year of the date of this decision, the Commission's executive director, that's who it was directing its order to, on behalf of the entire California Public Utilities Commission, shall make a formal written request, along with Southern California Edison Company and San Diego Gas and Electric Company, to the United States Department of the Navy to clarify the applicable site restoration remediation standards that will be required to terminate the San Onofre Nuclear Generating Station site lease, and shall meet and confer with the United States Department of the Navy to attempt execution of an amended site lease contract that explicitly reflects such clarified standards prior to the development of the San Onofre Generating Station cost estimates for the next NDCTP. Your Honor, the Alliance does not contest or challenge or seek to reverse any aspect of that order, nor does it question the conclusion of law on which the order is based.
So, Mr. Goodman, I'm starting, so is your point that the decommissioning cost estimate should be higher for the Navy site? Is that?
My point is that Edison has announced they've already collected enough money to meet the standards required by the Navy easement, and that it would be unreasonable now to allow them to weaken that cleanup standard. Neither Commissioner Florio nor any of his colleagues were members of this commission when the 2010 decision was adopted. They ought to be given the opportunity to judge whether or not it is reasonable for the state of California to sanction weakening the cleanup standards required in the current Navy lease.
So there should be no cost estimate reduction? Is that the point?
That's the point of my client's perspective.
Okay.
We do believe this issue is clearly within scope.
Okay. That's your second issue. What is your third?
The other 2, I believe they have both agreed are in scope. One is the reasonableness of the joint application's estimate of the length of time spent nuclear fuel will remain at the Song site. And the other is that because of the significance of the spent nuclear fuel storage assumption, the reasonableness of the joint application's request to reduce annual contributions to the trust.
All right, and what is your client's position on the schedule?
We will comply with any schedule agreeable to the parties.
Okay, sounds great. Finally, the Gilmore
Yeah, it's
group.
coming up here.
Yes.
Well, I'm looking at the almost $1.3 billion that's being planned to spend for the spent fuel storage system. And based on the information that I have, you might as well double that number. Because what Edison has done is they've made a decision without considering all options that I think if we actually went through this process with it, we will see that there's a much better decision out there. When I spoke to the NRC and I said, look, you're licensing a system for 20 years. In fact, on just this year, the NRC approved a Holtec UMAX system that Edison says they already have a license for. They said, well, it'll be good for 20 years. They specifically excluded San Onofre from this approval. San Onofre is not in. They said, well, we need another amendment from the vendor for the seismic issues. So, they actually named San Onofre in this approval as not. And then with the list of comments that were made to this UMAX approval of the system, I brought up to them, well, what about aging? What's going to happen after 20 years? In the approval, it says aging is out of scope. We only say it's good for 20 years, and we're not even looking at what the issues are for aging. It's out of scope.
So Ms. Gilmore, is your
My point is, the next point is, well, that's a cost. It's a cost issue, and that's the state's issue. We only look at safety. We don't look at cost. So it's really the burden. The NRC only looks at safety. They don't consider cost. So they're willing to say, okay, we know this is good for 20 years. And I go, but we need a system. We're going to be spending almost $1.3 billion. We need a system we know is going to last for a lot longer than 20 years. Because we don't have another $1.3 billion that we've been raising. So
Ms. Gilmore,
so it's up to the state to make sure that we have gone through the process to make sure that all the viable options are considered, to make sure that we're choosing something that's going to last longer than this. And the NRC obviously has to approve it, whatever the choice is, but the cost burden is up to us to make sure that they've made the best selection in terms of cost. What's going to hold up, what can be maintained, inspected, what's the replacement on the systems, that kind of thing, because it's going to affect our cost. And the NRC is not considering that.
all right, so Ms. Gilmore, is your position that the decommissioning cost estimate for spent fuel storage is too low by 100%?
I'm saying that the assumptions that Edison made to select what they selected are incorrect assumptions, and I think it should be in this proceeding to really examine the assumptions, and we'll find out that yes, they've made a bad decision here.
In this proceeding, we're looking at the cost consequences.
Yes, definitely a cost consequence.
And is it higher or lower?
Well, it's going to, we're going to end up having to replace the system prematurely, and they have not considered the maintenance and the aging issues of this system.
Okay, so it's your position that additional funds should be placed into the decommissioning trust?
If we stick with the decision they made,
Okay.
okay? I think they should have to look at more than what they've looked at, and we should have some say based on our cost concerns.
All right.
And then we may not need more money if if they spend it differently, we may not need more money. We could actually save money.
Okay, that's always a good thing.
Okay.
And your position on the schedule?
I think you guys should have Christmas.
All right, that's an excellent position.
Okay.
Okay, so anyone else that has, yes?
Thank you, Aaron. Don Kelly from UCAN. I arrived a little bit late, so I got to start the traffic room. I'm not sure if I have a motion pending for party status,
Yes.
and I'm willing to make comments now, if that's okay with you, or would you prefer me to wait until you roll on a motion?
Well, I think I can say yes to both because I will grant your motion right now and and now
I wasn't finished.
Oh, I'm sorry.
Sorry, I
No,
didn't.
yeah, Mr. Kelly, yes.
Okay, sorry, this is my first time doing this, so, okay. One of the other things to be aware of is Edison chose to go with this underground system, and it's within 100 feet of roughly 100 feet of the cliff, which is outside of the coastal act. So there's a lot more permit processes that have to happen before they even make a selection, and they seem to be jumping ahead doing things before they have all their ducks in a row, and that could, affect the cost issues. So they made a selection with no NRC approval, made a selection for something that's just clearly against the coastal act, and those kind of decisions are going to affect the cost. So continue bad decisions, and then
Yes, I'd like to make a point of law, please. Oh, I would like to make a point of law, please. Can you hear me?
Yes, I'd like you to identify
Oh,
yourself.
I'm so sorry. I'm Doris Shuey, and I'm a representative for Donna Gilmore. Sorry. I believe that SCE is laboring under a misperception regarding Administrative Law Judge Darling's rule in proceeding D14-12-082, because one of the things that was used to say that issues such as we're raising and Turn is raising and so forth are out of scope is because they quoted her decision saying issues regarding the type of nuclear fuel used in operations, the type of cask used for dry storage, the operation of the spent nuclear fuel pool are federal jurisdictional matters. So when she's talking about that, she is referring to federal jurisdiction under the Nuclear Regulatory Commission's radiological safety regulations, and we are not arguing that whatsoever. As John has just been explaining, and as other parties that want issues like this in scope 2 are raising, we're talking about cost concerns, and that is well within our mandate. And then further on in her decision, 14-12-082, Administrative Law Judge Darling actually quotes from the Supreme Court precedent, PG&E versus State Energy Resources Conservation and Development Commission, and saying, this is the quote, "The states retain their traditional responsibility in the field of regulating electrical utilities for determining questions of need, reliability, cost, and other related state concerns," and that's exactly what we're talking about, is cost and reliability. So I just wanted to bring up that point.
Thank you. All right, has that completed your presentation, Ms. Gilmore? All right, thank you. Back to Mr. Kelly.
Thank you.
New member with party status.
Thank you very much. And focusing, starting off with the issues regarding nuclear waste storage issues. I do think that cost is a big part of this proceeding in regards to how much we're going to be spending on the systems that Edison says are appropriate and reasonable to store this waste until it can be removed. Assuming that we actually get a decision from the federal government that can actually be taken off site sometime in the next century. And so I do think that the scope should contain two issues regarding this category. Are the costs associated with spent nuclear storage, as estimated by Edison, reasonable? And would an alternative to the utilities storage proposal provide a better value? I think that will having the scope, or having in scope those issues, will allow Ms. Gilmore to put forward her evidence regarding why she thinks that there are potentially huge costs to the ratepayers coming up if we don't heed the information she would like to present. It will allow Edison to put into testimony and put into evidence all the issues that they believe as to why the storage process that they believe is acceptable and cost-effective is appropriate. So if we could have as an issue, not only is their proposal reasonable, but would an alternative to the utilities proposal provide a better value, I think would be important.
Mr. Kelly, explain to me how you see those being different. One, to me, subsumed within the reasonableness standard is the idea that there's an alternative that would be preferable. And most often, if there's a preferable alternative, the other proposal is not reasonable.
And
So,
I totally agree with that. I just want to make it clear to the parties, when we were on the conference call a couple days ago, what exactly would be in scope other than the number of dollars that would be spent was an issue. And I do think it should be clarified, at least to the parties, and if this is the clarification we need, that's fine, that we can provide alternatives that may provide a better value, and that would be in scope. Because there was I believe it was Edison was saying, or the implication was that there are some things anything other than cost is not necessarily in scope with regards to this issue. And I just want to make sure that Ms. Gilmore and parties can actually argue for an alternative. And I agree.
arguing for an alternative, though, needs to be brought down to the point of cost.
Correct.
So you need to end at the point saying, Edison is estimating a cost of X. We think the cost should be Y, because.
Yes, and I agree with that.
And that's, more or less. That is the pivot point for all of your testimony. Everything has to come off of that.
I agree.
That if you can come off of that structure, then that's the essence of a cost estimate proceeding. So,
All right.
please continue, Mr. Kelly.
That's the first one, and I agree with that, thank you. Second one is with regards to the presumption of reasonableness. Edison, their testimony is asking for a presumption, specifically on page 45 of SCE 1. They're asking SCE's expenditures for those activities, which would be in the estimate, would be presumed reasonable. And the entity claiming that SCE acted unreasonably would, therefore, bear the burden of proving SCE acted. What SCE is asking for is a presumption and shift the burden. And that issue is pending rehearing. That issue has the commission precedent already established. That issue is not in scope in this proceeding, and it shouldn't be in scope in this proceeding. Unless the commission changes its precedent from a prior case, I see no reason why we should be spending our time arguing about it here. And finally, I don't want to echo anybody else, but thank you for doing my motion before time.
Thank you. Oh, and you have a position on the schedule?
Oh, and I agree with the order basis, not scheduled.
Okay. Thank you. All right. Does any other party have any comments? Yes, Mr. Lutz?
Okay, yes, so Ray Lutz with Citizens Oversight. I just wanted to make sure I got an acceptance of our other issues that we put in our pre-hearing conference statement. Just because I left them out of my comments here didn't mean I wasn't interested. I am very much interested in this reasonableness standard issue. I don't want to see the reasonableness standard diluted from what it was before. And it sounds like the utilities are attempting to do that, and apparently have even started to use a different reasonableness standard in their first set of testimony. And I guess that's why Kern was saying that it should be, redone. So I think that needs to, maybe they do need to be directed to come up with new testimony based on the original reasonableness standard versus this one that they just came up with. I did want to comment on something that you just said, which was that everything comes down to cost. And I don't agree with that, because there is a quality factor that we have to look at. What the utilities do is not just cost, it's also quality. What did they do when they spent the money? Was it crummy, or was it a high quality result? And so we have to look at the quality of what's done. So this is why when they say oh, we just want the reasonableness review to be, if we only spent what we said, everything is fine. We need to actually look back and see the quality of what they did. Did they do what they said, and did they do a good job? Okay, and so everything doesn't come down to cost. And with regard to the difference between, this is what I was asserting before, the NRC does not make big decisions for the state and for the CPUC. They don't tell us where to put the viscosity and the spent fuel. They just say these canisters are okay, and you can use these canisters or licensed, and there's debate about that. Okay, and so those issues are safety issues, but the NRC doesn't deal with them. So the CPUC rightly has some jurisdiction over these bigger questions that are safety, because indeed it does all come down to cost in a way. If you do something that's unsafe, then you have to clean it up, and you have to do something later. So I had those closing comments. Thank you.
All right, thank you, Ms. Lentz. Anyone else?
Your Honor, there seems to be, because we're talking about costs, there seems to be confusion about what exactly we're talking about when we talk about costs in this proceeding. So if this proceeding remains not consolidated, or at least it happens first, as Mr. Freeman has proposed, this concerns the decommissioning cost estimate. And as you have pointed out several times when discussing issues with parties, the purpose of the decommissioning cost estimate is to determine whether the utilities have sufficient funds in their trusts to complete the decommissioning work. So we should be looking at the assumptions under the decommissioning estimate themselves to decide whether the funds in the trust are sufficient, or if we need to ask for contributions from ratepayers, whether our proposed rates are just and reasonable. The issue about how the utilities spend the funds is in a different proceeding. That's in the either triennial or the other proceeding going on right now for 2014 costs, which is a backwards-looking reasonableness review of management decisions, how money was spent on the site itself. What I don't want to happen is this proceeding having issues that bleed over into that other proceeding. Right now, we should be looking at the DC as an estimate as it relates to sufficient trust money, not whether the estimate is a guide or a work plan or a fixed schedule of what we're asking to do. Again, those types of issues about how the money is actually spent, that's in a separate proceeding.
All right, thank you, Mr. Lustro. Mr. Matthews, you want to conclude?
Yes, Your Honor, thank you. SE agrees with the statements that SDG&E just made regarding what should be the focus of this proceeding. Some of what I've heard the parties say regarding, for example, selection of various technology and vendors, as it relates to whether or not SE's underlying assumptions in the DCE are appropriate or proper, and have they, we have sufficient funds in our DCE for those purposes. We agree that those issues are in scope. So the disagreement is to the extent that a party is suggesting that in 2013 and 2014 we should have done something else. That type of issue should be the focus of the reasonableness review. That's in a separate application. I did want to briefly touch upon a couple of the comments that were made on the consolidation point. SE does not take a position on consolidation, but we do agree that in sequencing the proceedings is an approach that could be taken. Citizens Oversight made a point regarding stopping work while the DC is pending. That is not a workable option to consider. Should not be considered. We recognize that activities and the costs that we are incurring are going to be subject to subsequent reasonableness reviews. That's the position that we're in with shutdown decision, and the fact that we need to have this DC approved while we're still doing work. That's the situation that we're in, and we again recognize that what we're doing is subject to review. the work can't be stopped. I think I'll stop with my comments there. Again, we think that this proceeding should be straightforward. I'll also note that SCE has submitted a number of DCEs for songs 2 and 3, for songs 2 and 3 decommissioning and prior NDCTPs. And in fact, this DCE, although it utilized a different methodology, and it's a site-specific DCE, and it's our current DCE, is consistent with the DCE that the Commission just approved in the 2012 NDCTP decision 4 months ago. There are some differences. We've noted those differences in our testimony. Those are the types of issues that should be considered in this proceeding.
All right, thank you, Mr. Matthews.
May I make one last comment on behalf of ORA? The discussion about the consolidation of proceedings, if they are consolidated, if this application 14-12-007 is consolidated with the application 15-02-006, ORA proposed a different schedule in the application 15-02-006 because of the availability of ORA auditors. We don't have any available that would be able to work on the schedule we proposed in the 2014 application. And so if the cases are consolidated, we would ask the schedule be adopted that we proposed in the 2015 application.
All right, thank you, Mr. Disco. All right, we're going to go off the record, take about a 7-minute break so that we can confer, and then...
Could I ask a question of the utilities? We're parsing some fairly fine points here. And I understand your position is this case is ultimately about the adequacy of the trust. But if the Commission were to agree with Ms. Gilmore that the $1.3 billion for spent fuel storage would have to be spent again, doesn't that go directly to the adequacy of the trust?
Well, the disagreement that we have with Ms. Gilmore is that she's made some specific allegations regarding the technology that we've selected. The allegations that she is making regarding stress corrosion, cracking, and those types of issues are, in our view, clearly within the jurisdiction of the NRC. It's speculative to raise those types of issues here, and it should not be within scope. There are a number of events that could happen that could increase costs, and we don't think that type of speculation on radiological health and safety issues is within scope.
But, if there's a difference of over $1 billion in what the ultimate cost might be, how can we not address that question?
We can, so that question can be addressed to a certain extent. So first, we would have to discuss, well, how did Edison and the DCE come up with the estimate for how much it'll cost to store the fuel? And then then the burden shifts to the parties to show that for whatever reason, that estimate is not reasonable, and this is how much it should be. And then we would have to gather more information from ratepayers for the trust funds. But in terms of what decisions may have already been made, those will be judged in a backwards-looking reasonableness review later. So it is difficult to parse them, but they are separate. We certainly don't want to get bogged into a situation where we are being essentially told in this proceeding what management decisions we have to make in the future. Again, this needs to be focused on, are our trusts sufficient based on the assumptions in the estimate? And while there is a nuanced difference, there is one.
Yeah, I would agree with that. I think one of the difficulties with the way Ms. Gilmore has framed the issue is that it would put, basically is requesting the Commission to issue a decision regarding what types of operational decisions the utilities make. And that's not the proper role of the commission. The commission can review that certainly, but to put that on the front end of the commission, directing the utilities to select certain technology and certain vendors, in our view, is not the role of the commission.
If I could elaborate on that a little bit.
In the context of Public Utilities Code, Section 761, it's not in our jurisdiction.
As it relates to radiological health and safety concerns.
Take, for example, the issue of the canisters.
Yeah.
So what Ms. Gilmore would be proposing to do would be for this commission to second guess decisions that the NRC has made. And that is outside the scope.
Well, as I understand it, is Ms. Gilmore correct that they have not made a decision about the suitability of this type of canister for songs specifically?
It is my understanding that NRC has not made a determination as it relates to songs and the particular site where the ISFC is to be located. But that applies to all technology. There's no technology out there that has been licensed by the NRC specifically for songs. So the kinds of issues that to the extent that that's the issue that's raising.
That's not true.
That, well.
Okay, wait, this is exactly what we want to avoid and getting into all of these issues. I think the way this comes together, rather than trying to second guess the NRC, what we do here is second guess the estimate and say, we're planning on this, but there's a risk. So, and the way we do that often is a contingency factor. And we say, well, there's a risk that number might not be enough, so we're going to build in a cushion. That's how it's done in a rate-making way, and you don't get into the particulars of the issues so that we don't get into all of this. Mr. Matthews, I think you've had enough.
Well, I do.
One very quick
I just want to correct myself because I misstated what I just said, and that is the REBA technology, the existing technology, is licensed for the site. So I just want to make that correction.
Okay, thank you. Thank you. Okay, we're
Could I
going.
ask one other question? I'm sorry. This is my first time doing one of these proceedings, and my knowledge is limited. I understand that there has been litigation in the past with the federal government about, their failure to take control of the nuclear waste, and that the utilities have received some money back because of that. To what extent are these costs that we're talking about for the spent fuel storage something that there's an expectation would be funded by the government at some point in the future? And where do we stand on that?
There is active litigation, and there will be future claims made. We've already had one round of litigation that had damages through, I believe it was the end of 2005. It's either 5 or 6. There's a current claim that's pending that has damages from the end of the prior litigation all the way through 2013. We will continue to make claims against the government for those damages. The way it proceeded for round 1 and our expectation going forward is that those refunds will be, the damages received from the government will be refunded back to ratepayers in an era consistent with the rate making that existed when the funds were collected. So in a sense, the money that we are spending for spent fuel management will be the subject of future litigation to the extent that they relate to the portion of the costs that were incurred due to the government's failure to pick up the fuel.
Your Honor, if I may, in 2012 in the CTP, the issue of whether or not some of these future DOE litigation expected settlements should be credited against the estimates was raised by turn in the hearing and litigated. And in the 2012 NDCTP decision, the Commission found that at this time, future recoveries was not yet certain enough to to assume going forward that those recoveries will be offset against the estimate.
Yes, Ms. Lestro?
And Commissioner Florio, just to expand on what Ms. Howe-Downing said, is right now the utilities do not have a certain expectation of recovery from the DOE. The DOE always litigates to the end, is what we've been experiencing. We're not in settlement discussions with the DOE. We have not filed a claim for costs from 2014. It's either 2014 or 2015 forward. We have a pending one right now. And so we must remember that the time between when the utilities incur these expenses, the time that we may be successful in obtaining a damage award from the DOE is as long as 10 years. So to sit around and say, well, eventually we'll get, hopefully, money from the DOE in the form of a damage award, the fact is we can't base our current spending on that possibility. We still will continue to incur those costs while we're litigating.
And fundamentally, making refunds is always easy. Further questions, Commissioner?
Mr. Eastman had something to say.
I was just going to point out that as capable as the utility litigators have been, they have not yet been able to recover 100% of their claims.
Okay. All right, thank you. What we're going to do is take a 7-minute break. No, we need to stop. We need to stop and wrap this up schedule-wise. So we will be in recess till 3:25.
Yeah.
All right, artists, if you'd like to be seated, then we'll
Okay, great.
We've had a lot of points.
It directly relates to what SDE and SDG&E were just saying.
All right, we'll be back on the record. Ms. Merrigan, you have a brief comment you'd like to make?
It is brief. And
All right.
I just wanted to, Ms. Solistro was talking about not wanting to get bogged down, and Mr. Matthews wants an expeditious review. But in our pre-hearing conference statement, we cited section 8326 of the California Public Utilities Code, and it actually states that the decommissioning cost estimate has to have a description of changes in regulation, technology, and economics affecting the estimate of costs. And that is exactly what Ms. Gilmore is trying to offer here. So I just wanted to get that in.
Thank you, Ms. Merrigan. All right, while we were in recess, the Commissioner and I and the assigned administrative law judge for the other two proceedings, as well as our advisors conferred. We will be further conferring with the assigned commissioner on those other two proceedings, but at this point, we're leaning towards a sequential handling of those three proceedings. That issue will be addressed in the scoping memo, as will all other issues related to the scope of this proceeding. The procedural schedule, I won't bother reading it into the record, but we will, why don't I go ahead and do that, just so we all have it in the transcript. The procedural schedule that we will adopt is from the Office for Repair Advocates March 20th filing, with the addition of the first date being May 11th. Southern California Edison will file its supplemental testimony. Oh, I misspoke. I said file. They will distribute their supplemental testimony. Intervenor testimony will be distributed on July 15th. Rebuttal testimony from the applicants will be on August 3rd, 2015. We'll have evidentiary hearings here in San Francisco in mid to late August, depending on our scheduling. What is the party's estimate for how many days of hearings we expect?
I would estimate, I think 2 to 3 days would be
2 to 3?
sufficient.
All right, we'll go with 3.
And Your Honor, on that point, I was able to confer with counsel for Turn and also Edison, just based on availability of counsel and also witnesses. And within that block of time for the hearings, it appears that the span between August 20th and August 27th would work best.
All right. All right, I will put that request into the court reporters and see what we can come up with schedule-wise to make that work. But that would be my first choice, schedule-wise. All right, and then we will set the briefing schedule at the conclusion of hearings. So we will not be adopting the briefing schedule that is set forth in ORA's filing. And the proposed decision will be issued after the conclusion of briefing. Is there, finally, I want to thank all the parties who are present today for all of their positions that you've very well and carefully articulated. I think these are very important points that the commission needs to consider as we put together our scoping memo and as we move forward in addressing this very important issue for everyone in the state of California. So thank you very much for being here and offering your expertise. With that then, this pre-hearing conference is concluded and the commission is adjourned. Thank you.
Thank you.